next speaker is going to talk with us about how to avoid the disciplinary system with the bar. Attorneys licensed to practice in the Commonwealth enjoy the privilege of self-regulation, and this is done through a network of volunteers with the bar and trained professionals under the leadership and guidance of the Office of Bar Counsel. Our speaker today is Ned Davis, who assumed the role of Bar Counsel in June of 2008. Prior to becoming Bar Counsel, Ned served as an assistant Bar Counsel beginning in 1993 and has prosecuted many high-profile cases in the Commonwealth. He has served all of the state bar district committees and has also prosecuted matters before the Virginia State Bar Disciplinary Board and the 3-judge panels for the circuit court proceedings. So as you can imagine, such a position would require an inordinate amount of legal knowledge, skill, and the application of common sense. Before coming to the bar, Ned served 6 years on active duty in the United States Army JAG Corps, and then was Deputy Commonwealth Attorney for York County. From 1991 to 1993, he had a general practice here in Richmond with Stuart Simon and Associates, and focused on criminal defense and domestic relations law. Ned also continued to serve the Army and retired from the Army Reserve in January of 2009 with the rank of Colonel. He received his undergraduate education from William & Marion, his law degree from the University of Richmond, and holds a master's degree in strategic studies from the U.S. Army War College. He's married to Amy Hope Davis, who is also an attorney practicing with Anthem Insurance Company, and they have 5 kids. I've worked with 4 bar counsels over the course of my legal career, and I'm pleased to report that our bar's disciplinary system is in great hands with my friend Ned Davis. Please welcome Ned.
John, thank you very much for that introduction. There are 2 parts to this presentation. We have the PowerPoint slides behind us that I'll get to if we do have time. I've got about 2 hours of material and about 30 minutes to cover. The other part is a summary by William Glover, a former chair of the Disciplinary Board, who gives some pointers based on his observations, and I'll talk about those a little bit. Everybody should have gotten this with their materials. You've probably heard this all day and will continue to hear it. I commend it to you. Please glance at it. It has a lot of common sense advice based on his observations, and I'll tell you a little bit more about it based on my own experiences as well. As John said, we are a self-regulated profession in Virginia. We don't have another independent agency that oversees what we do, and that is driven by volunteers. There are about 800 volunteers who serve the Virginia State Bar in one respect or another. And other than the Supreme Court of Virginia, which ultimately determines whether a lawyer loses their law license or has it reinstated, there is no agency, if you will, that oversees what we do. It is the volunteers that do. And John, I got to know John back when he was with something called the Committee on Lawyer Discipline, a panel of volunteers selected by the president of the Virginia State Bar that provides general oversight of the disciplinary system. And once a month, John would look at my disciplinary dockets and ask questions about why something wasn't moving and just ensure that we were doing the best that we could do with our jobs, and that panel exists today. Excuse me. There are many ways to be involved. Most of you are new practitioners and you might want to be out for a little while, but the most immediate way to be involved in the disciplinary process is by being a member of a district committee. You might want to wait 5 years before putting your name in the hat for this, but the district committees are organized by circuits throughout the Commonwealth of Virginia, and they are the first tier of review outside of our office when the bar is investigating a case and seeking disciplinary action. They may decide to dismiss a case that's been investigated. They may decide to have it heard by a district committee, which is in the local community or the local circuit where the lawyer complained of resides, and they can impose a reprimand or send it further up to the disciplinary board that meets in Richmond, which has the authority to suspend or revoke an attorney's license. But again, they're made up of volunteers from the circuit. 7 lawyers on each district committee and 3 non-lawyers. 170 volunteers altogether, 170 serve in this capacity throughout the state. And again, a few years down the road, if you want to be involved in the process, that's the way to do it. How do you get involved? Furnish your name and bio to the Virginia State Bar's Executive Director. The selections are made by the Bar Council, spelled C-O-U-N-C-I-L. Those are elected volunteers who also provide oversight of the Virginia State Bar and its operations. They're the ones that make the selections. If you happen to know who your council representative is, furnish your name and information to them, and they will make the selections. But before time gets away from us, let me just take a look at Mr. Glover's summary. His first point is know the rules. You're not going to sit down and study the rules and have them all committed to memory. They are counterintuitive, though. Conflicts are a unique issue, unique question. And just simple things like contact with a represented party, Rule 4.2. It's an issue that comes up all the time, and I'll talk a little bit later on about the handling of client money. That's governed by the rules of professional conduct also, and can lead to discipline. But the bar has a service available to all of you, free of charge, and that's the ethics hotline. Let me give you that telephone number. It's area code 804-775-0564. 775-0564. Jim McCauley, who heads that department, has been with the bar more than 20 years. For lack of better words, he really knows his stuff. And when you call this department, your advice will be on a confidential basis, even though those lawyers report to me ultimately as part of the Department of Professional Regulation. Their records by operation of rules of the Supreme Court of Virginia are confidential and cannot be disclosed without your consent. And that rarely comes to the fore. But not only is the telephone service available to you, inquiries can be sent by email as well. You're at court, you got a hot question, you don't know what to do, you can use your handheld to send a text inquiry to the bar's ethics department. That email address is available on our website. It's too long to simply repeat here today, but I ask you to go to VSB.org and see how you can make an ethics inquiry and have that available to you if you are in a pickle somewhere. It's an evolving process that is much better than it was 20-some years ago when I was in the prosecutor's office. I frequently had questions about conflicts, and when I called the bar, I would usually get a paralegal who could steer me to different legal ethics opinions as suggested reading. But I didn't get that confidential attorney-client advice that's available to you now. And there are 4 lawyers on staff that do that. That is their full-time job. The volume of business on the ethics hotline continues to grow. It's grown by about 16, 17, or 18% in recent years. And coinciding with that has been a drop in the overall complaints made about lawyers to our organization. I can't prove a connection, but there is clearly a correlation. And so I just can't put a high enough price tag on this service that, again, is available to you. Another one of Bill Glover's comments, William Glover's comments, be sober. Well, we all want to win. We're in a high-powered, high-tense profession. We're all competitors, and in an emotional and highly charged environment that we're in, a high-pressure environment, sometimes people do have various emotional or perhaps substance abuse problems. There is another service available to you free of charge. It's not a Virginia State Bar organization, although we do provide them with financial support, and it's called Lawyers Helping Lawyers, LHL. Area code 804-644-3212. 644-3212. They're there to help, and they do a very good job with it. And just because you want to call or someone suggests you call Lawyers Helping Lawyers does not mean you have a substance abuse issue. They're equipped to deal with all the other emotional and mental health related problems that affect all of us lawyers. Depression is an extremely profound and aggressive malady, if you will, that affects many lawyers. It can affect their ability to be timely in working their cases and paying attention to their work. This organization is there to help, and I just urge you to jot that number down. And if you know another lawyer that is always late to work, late to court, not paying attention, not returning calls from clients, you can urge this person to contact Lawyers Helping Lawyers. And just about every circuit in the Commonwealth has a volunteer liaison with Lawyers Helping Lawyers too, who is there to help. And again, what they do is on a confidential basis as well. And this is addressed in the rules of professional conduct. All of us as lawyers have an obligation to report misconduct by another lawyer that involves conduct involving fraud, deceit, or misrepresentation or other misconduct that substantially affects a lawyer's honesty, trustworthiness, or fitness to practice law. Information learned during an interview or session with Lawyers Helping Lawyers is always protected from liability. So that's something to keep in mind. Again, an organization there to protect you or your colleagues free of charge and on a confidential basis. Let me touch on a few other of Mr. Glover's points, and a lot of this is common sense, but again, some of it is counterintuitive. His point number 2, be part of the solution, not the problem. Sometimes lawyers get in trouble because they become too personally involved in their client's case and want to be on their client's side and may not give objective advice to their client about what the client's trying to accomplish. And just certainly at the same time, you don't want to compromise a case by not taking action that you should take because you are trying to win over your client, if you will, rather than doing what is required under the rules of professional conduct. We do have an ethical obligation to follow and pursue our client's objectives, but not if the client's objectives are contrary to the rules of professional conduct. Point 3, practice in your comfort zone. It is not unethical. It's not unethical to accept a case in which you have no experience, as long as you become proficient in the area of law in a timely manner and/or associate with another lawyer that is well practiced in that area of law. But there are some areas where you simply should not, if you will, dabble. One is immigration law, and another is bankruptcy law. We find more lawyers getting in trouble in these areas. They will accept high fees from clients. They don't regularly practice in these areas. And bankruptcy practice now requires quite a bit of training and education. There are deadlines to meet. Some lawyers who don't do this on a regular basis will not handle their client's case the way they should. Immigration law is a highly tempting area for lawyers to accept high fees, but if one is not practicing in this area, it can lead to severe trouble. And lots of otherwise good lawyers have suffered discipline as a result. But otherwise, stay in tune with other lawyers in your profession and learn how to handle new kinds of cases. 4, communicate. If there is any way to get your client upset and complain about you to the bar, it's not responding to their inquiries about your case and not keeping them informed. And it's human nature, if one can't get to the case and do what the client expects them to do, it's human nature for many not to want to respond to that telephone call. But you are required under the rules to timely respond to reasonable requests for information from your client. That's Rule 1.4, and keep them informed about any developments in the case, especially developments from or communications from another party or the other side that may affect the outcome of the case. Sometimes called back burner syndrome. Goes hand in hand with diligence and avoiding neglect. Even if you can't get to the case, call the client out, write them something. Here's what I'm doing, here's what I plan to do, here's my direct line, call me anytime. And usually, even if you can't get to the case, that will be enough. At the same time, though, our ethics opinions have held that any client that hires a lawyer is entitled to expect timely and diligent movement of the case as well. And if you know that you can't get to the case or learn that you can't get to it, that give you the time to talk to your client about what to do and maybe even bring another lawyer into the case and handle it. But not getting to the case when you can, and especially not responding to client inquiries, I guarantee you, will steer them to the Virginia State Bar. 5, don't procrastinate. Really ties in with what I just said. Clients are entitled to timely action on a case in which they hire you. and at the same time, if you're not proficient in the area, associate with another lawyer. I mentioned this, many of you are going to go to work with law firms where you have built-in structure. Some of you will go into smaller practices or sharing office space, but utilize other lawyers and organizations for help. For example, as John said, I love criminal law. I love defending criminal cases. For those of you who get in that profession, for some reason it's a lot easier than prosecuting them. For many reasons it is, and that's what I did during the best years of my life. But join local criminal bars. You'll find lawyers out there, or other local specialty bars, and they're throughout the state for whatever your area of practice is. You'll find that there are plenty of seasoned lawyers who are in these organizations who are very generous with their time and will help you with your questions. They're glad to do it. Some local bars sponsor CLE programs that are very affordable. And for that reason, it's good to be involved. The Richmond Bar, for example, sponsors ongoing CLE programs for very affordable prices for young practitioners that don't have a big head out of which to pull money. I mentioned the hotline, but one that is not on this list, but I have to mention, and that is accounting for client money. All of us are ethically required to account for unearned client fees. If you work at a law firm, chances are there will be an accounting department or senior partners who receive the money and account for it, and you're never involved in that. If you're in a smaller practice, chances are you may be receiving payment directly from the client. You may be the one who is the named person on the account responsible for managing that money. It's easy to do, but easy to get away from. And it rips my heart out when I see so many lawyers who are accomplished trial lawyers, know how to engage a jury, know how to argue a case, know how to present all the trendy defenses and do very well, don't handle client money properly. And they will lose accounting for it. The client expects money to be used for one thing, the lawyer says it was for something else, and if they don't have the records, they can't prove it. Something called a subsidiary ledger. When you're paid for a case in advance, you have to account for each disbursement from that balance of money. And you don't pay yourself until you've done the work. It's one thing that does get lawyers in trouble also. Client may pay you $10,000 on day one to defend them in a criminal case. They can fire you on day two, and they would be entitled to a refund. But if you converted that money, you violated the rules of professional conduct. There are so many automated programs out there now. Quicken Books, for example, I'm not promoting any product, but it's so easily done, and any other more detailed questions about how to handle client money are available on the bar's website. There's a book called Lawyers and Other People's Money. It's available in electronic format on the bar's webpage, and if you read Rule 1.15, that's the one that covers accounting for client money. You're going to look at it, you're going to say, what's a subsidiary ledger? What is a cash receipts journal? What's a cash disbursements journal? What is a periodic reconciliation ledger? Certainly you're not going to understand what all that is, although a lot of it is similar to what you see in a checkbook. But all the forms are in the book, Lawyers and Other People's Money. And if you use an automated program, you can put the information in, and they will print out the reconciliations, the ledgers, and everything else you need. But I'll see lawyers get in trouble when the client pays them $2,500 for a case. And for some reason, the lawyer can't finish the case and the client expects a refund. All right, you put in 2 months on this case. We got to the point where it goes to trial, but you're not available. I'm entitled to a refund. The lawyer says, well, yeah, I put in about $1,000 worth of work on this case, but the other $1,500 I used for that second case that you hired me for. And the client says, no, I'm supposed to pay you for that later. I need you to give me my $1,500 back now. And without the records, without something in writing discussing the use and disbursement of this fee, there's a dispute, and that can lead to trouble. And the lawyer is responsible for those records. Trust account overdrafts. Any bank that is an approved financial institution for handling lawyer trust accounts is required to report to the Virginia State Bar any overdraft against a lawyer's trust account. If your trust account is overdrawn, you'll get a letter from the bar saying, explain to us immediately. Sometimes it is bank error. Sometimes it may be a bank fee that the lawyer didn't anticipate. The best way to avoid that is maintain your general account at the same financial institution and have an agreement with the financial institution for all bank fees to be withdrawn from your general account and not from the trust account. But you don't have to do that. You don't have to do that. Rules also allow a lawyer to keep a little bit, I'll say a little bit, actually thousands of dollars of slush, if you will, of a trust account to avoid problems with bank fees being taken out of the account. But otherwise, overdrafts frequently are an indication of attorney neglect in handling client money. If we get a second report of an overdraft in the 12-month period, we're not going to just ask for an explanation. We're going to pay you a visit. We're going to ask to see those books. And some lawyers have been in the unfortunate position of not having a subsidiary ledgers, not having proof of reconciliations, and that's why they overdrew the account. Also, it turns out, and I had trouble understanding this myself, but overdrafts from the trust account are sometimes an indication of theft. We have had some lawyers who have stolen millions of dollars from clients, and the misconduct had its origins in overdraft from the trust account, which some of these lawyers were able to explain, but ultimately clients lost money. I can't put enough emphasis on that. Easily done, but easy to get away from. In the few minutes I have, let's talk a little bit about what we do in the disciplinary section. If we have a few minutes, I'll talk about some disciplinary cases that may interest you. As I mentioned, less than 3,900 complaints in the fiscal year that ended last summer. We actually received more in 2011, but the number is going back down. Then you see the number has dropped in 2010, 2009. We had as many as 5,000 complaints in other years. The granddaddy of them all is in criminal practice. I'll tell you a little bit about what that might involve. The grand majority of those are lawyers representing indigent clients. That means appointed counsel who don't follow through on appeals and let them lapse without explanation and without telling their clients. It's been a huge problem, not just in Virginia, but elsewhere. It was the subject of a series of articles in the Washington Post many years ago. Since that time, we've audited the files from the appellate courts, and the appellate courts now report to us any case dismissed because of an attorney missing a filing deadline or misformatting a petition for appeal, for example, those kinds of things that result in dismissal. And we'll investigate. And frequently, there is an explanation, client when the appeal was wrong, and I'll tell you, the Court of Appeals, if you're ever in that situation, they won't let you withdraw an appeal unless you have an affidavit from your client indicating they want the appeal withdrawn. Otherwise, they'll report it to the bar if it's not finished. But lawyers keep doing this. There are statutes out there allowing a dismissed appeal to be reinstated to the docket. 19.2-351.1 and 351.2, I think, are those statutes. So if you have an appeal dismissed because of your own mistake, you can get it back on the docket. And if a lawyer does that, chances are we're not going to seek any disciplinary action. The bar does not punish lawyers for a single act of inadvertence or neglect if they communicate the error to the client and take remedial measures. Do we find lawyers guilty when the complaint comes in? No. As you can see, more than half of the complaints were resolved by our reviewing attorneys with no action taken. If a complaint on its face does not set forth a violation of the rules of professional conduct, we tell the complaining party that we don't even involve the lawyer. Many more, 763 cases involving minor misconduct. That is, my lawyer, I have a trial coming up and I can't reach my lawyer, or I fired my lawyer and I can't get the file from them. That on its face does state misconduct. Rather than create a disciplinary record or a formal disciplinary file, we'll send a letter to the lawyer saying, here's what your client says, please do something, let us know what you've done. 763 cases were closed in that fashion. Either the lawyer showing they turned the file over to the client, or a lawyer sends a copy of a letter that's sent to the client in response to that, and we'll take no further action. And that number continues to go up every year. The rest, 27%, were formally assigned for detailed investigation. Many of those were dismissed, though, upon further review by staff attorneys, and the rest were assigned to bar staff investigators. And some of those are dismissed too, some lead to disciplinary action. This pie chart shows the area of law. Again, criminal leading the way, family law second. Frequently complaints come from the clients of opposing counsel. It's just an area of practice where it's very difficult for everybody to come out happy. Civil litigation, just involving missing deadlines. Real estate, not timely dispersing after real estate closings. Occasional problems. Personal injury, the client that has that unreasonable expectation of a fixed amount of money. They don't get it, they're going to let us know. That doesn't mean we discipline the lawyer, but just a point to take from that is that if you're going to do that kind of work, talk to your client routinely about what their expectations are and what they should expect to get. Otherwise, there could be a misunderstanding. Estate planning. Lawyers that are late in preparing the inventories and the accountings that are required under the Code of Virginia. If the Commissioner of Accounts does not get those on time, they'll ask for from the lawyer with something called a delinquency letter. If that doesn't lead to the accountings or inventory, they'll issue a summons. And if the lawyer still hasn't turned in those documents, they're required by law to report it to the Virginia State Bar. And lawyers who handle estates and just don't know how to get that kind of work done might get in trouble. And sometimes cases like that reveal misconduct or embezzlement as well. I'm close to running out of time. I'm going to try and speed this up. I mentioned bankruptcy and immigration. Let me touch base with criminal law as well. It's not just defense lawyers that get in trouble. We do get complaints about prosecutors, but for different things. Rule 4.2, communicating with the defendant as a lawyer without that lawyer's consent. It happens, and it leads to disciplinary action. Rule 3.8, the requirement to disclose exculpatory information. But more importantly, if you prosecute cases and you know a government witness is lying, you have an obligation to get with that witness and have him correct the wrong, or otherwise you got to inform the tribunal. We had two prosecutors disciplined just in the last year who observed a government witness testifying against a co-defendant, and they said something like, well, I've got no agreement with the government, or I'm not expecting anything from the government, when the prosecutor, either sitting in the audience or trying the case, knew that they had discussed plea agreements with the government and there were concessions discussed that involved their testimony. Public reprimands, one out of Fairfax County, another out of York County, where I worked many years ago. For those of you with quantitative minds, here are the numbers of cases we investigated, getting back to criminal law. Fewer complaints against prosecutors, but by sheer coincidence, we investigate 13% of the complaints against defense lawyers. We investigate 13% of the complaints against prosecutors. Just worked out that way. I see I'm really about to run out of time. I mentioned to you procedural defaults on appeal in the back of Burner syndrome. This Pickus case is very old, but it has withstood the test of time. Neglect usually involves more than one single act or omission and can't be found if the acts or omissions were inadvertent or result of an error in judgment made in good faith. But a pattern of that can lead to disciplinary action. We discussed not being able to handle a case due to lack of efficiency in the area or just the consequences of a busy practice. I'll talk, if I've got a couple of minutes, about some disciplinary cases that may be of interest to you. Mr. Agresto was one of those lawyers that did not handle his criminal appeals as he was required to do. He didn't inform his clients. Advised the bar that he had. The client said that he hadn't, and he didn't have any letters or anything to corroborate his allegation that he did inform his clients. He also had a lengthy disciplinary record. His license was suspended by the disciplinary board, and by sheer coincidence, while that was going on, he was indicted for conspiracy to commit wire fraud. Those of you ever involved in federal practice, wire fraud, how do you prove that? All you need is a telephone call. That's all you need. And if it involves discussion of criminal conduct, it can lead to a conviction of wire fraud. But complicated matter in which his client was accused of murdering his spouse and the insurance company did not want to pay over the life insurance. Mr. Agresto approached the insurance company indicating he would put the money in trust for the benefit of the daughter. He didn't know he gave some to himself and gave some to his client. Just utterly dishonest conduct by a lawyer, and he consented to the revocation of his license, did not confess the charges with the bar. But we have a few out there that do those kinds of things. Bamberger, a high-profile matter that came out of the Monica Goodlake matter, if any of you remember a few years ago, out of the White House, and just some dishonest conduct, but issued a press release that was improper, but it was released in a district committee. I believe in Alexandria agreed to a reprimand and nothing further. Dobbins was a bankruptcy lawyer who committed all kinds of errors over the years of his practice. The bankruptcy court revoked his privilege to practice, and the Virginia State Bar imposed something called reciprocal discipline. Your license is suspended or revoked in another jurisdiction. You face the same discipline here in Virginia. A bankruptcy court is deemed to be another jurisdiction for those purposes, as is federal court, and as is military courts, if many of you know someone who handles court martials. I'm just about out of time, but this is another lawyer who occupied a position of trust with clients, handled many trusts. We were getting telephone calls from beneficiaries who weren't receiving their money. We subpoenaed his records. He didn't turn those over. We're allowed to seek a summary suspension of a lawyer's license if they do not furnish records in response to subpoena. But meanwhile, seeing what appeared to be criminal conduct, we coordinated with the United States Attorney's Office, who got the Postal Service involved and indicted him for wire fraud after the disciplinary board revoked his license for the same misconduct. He was sentenced to a period of time in prison. He had a nice boat out in his home in Virginia Beach, but suddenly, though, as my colleague said, for once he got to watch the sunset from the prison yard instead of from his boat, from the yard arm to the prison yard. Let me get to one more case that may interest you before we go. John Warren Clark was a Virginia Beach lawyer, similar misconduct, but evidence of what he had done was available from bank records, and he consented for revocation of his license. Cantro was he was involved in his own divorce and was accused of concealing assets from the divorce judge. He received a personal injury payout from a case he handled and used the money to set up a trust for the benefit of his mother. The unique thing about this case was the bar was able to have testimony from his own divorce lawyer and got around the attorney-client privilege through something called the fraud exception. The three-judge circuit court that heard this case agreed with the bar, heard testimony from his lawyer, and suspended his license. Revoked his license. Back here. Bambi Walters is not a Virginia lawyer, but she had an office in Williamsburg saying Bambi Walters, attorney at law. If you hold yourself out as a lawyer, that's the unauthorized practice of law. Her explanation was that she handled patent and trademark law, which doesn't require a Virginia license to do, but the evidence was that she handled quite a few other matters as well that required a Virginia license. We reported this to the Commonwealth. That is a crime. It's a Class 1 misdemeanor, and they didn't prosecute her for the unauthorized practice of law. The district court found the evidence sufficient but took it under advisement. Meanwhile, what jurisdiction does the Virginia State Bar have over her? The rules have changed. Now a non-Virginia lawyer that holds himself out as a lawyer in Virginia is subject to discipline by Virginia. We didn't prosecute her even though she never held a Virginia license, and our disciplinary authorities now have the ability to suspend or revoke a lawyer's privilege to practice in Virginia. She did agree to a 2-year suspension of her privilege to practice in Virginia. That was reported to the states where she did have a license, I think, North Carolina and Louisiana, which imposed reciprocal discipline. That is, took her true license to practice law away as well. You may have heard about some appeals to the Supreme Court of Virginia. A lawyer advertising case was sustained in part. If you ever have any questions about posting case results, and the disclaimers that are required, please contact the ethics hotline. The Supreme Court is seeing that against a First Amendment challenge. The other cases, we had an unusual year in which the Supreme Court reversed two other disciplinary actions. It seemed to be based on the facts. A case named Zog, a lawyer accused of a 1-minute telephone conversation with an opposing party who was represented by counsel. The Supreme Court did just reverse and dismiss that on appeal, finding the lawyer, by the time the lawyer did know they were talking to a represented party, they took reasonable action to end the call. The case was heard by a district committee which found misconduct. She appealed to the disciplinary board, which sustained it, but the Supreme Court, in its discretion, took a different stance. And the other case involved conflicts as well, and the Supreme Court found the disciplinary action was not appropriate. In closing, let me mention one thing. I don't have an exhibit for this, but if you did get a complaint from the bar, it helps to consult with counsel. Many insurance companies provide counsel for responding to bar complaints. But it does help to be thorough, but it helps to consult with counsel because some lawyers responding to bar complaints are too thorough, and even though they didn't do anything wrong, they reveal something that is misconduct nonetheless. For that reason, it's good to touch base, but it has to be thorough because if you are, and you know you didn't do something wrong, we'll see it from your response, and we won't take any further action. But getting back to criminal appeals, there was a lawyer out of John's neck of the woods many years ago who handled an appeal for a court-appointed client, took it to the Court of Appeals of Virginia, got a writ, and argued the case, but the conviction was affirmed. The client wanted him to appeal to the Supreme Court of Virginia. This is an indigent client, and by the Constitution of Virginia and case law, any indigent client is entitled to representation by appointed counsel through the Supreme Court of Virginia. The lawyer said, well, I'll get back to you. About a year went by, and once the case was certified with no appeal pending, this client was out on bond. Pending the appeal, he got a call from his probation officer saying, well, your case is affirmed at the Court of Appeals, nothing's pending, I need you to report to me and start serving your jail sentence. He went to the lawyer, and the lawyer said, no, I didn't tell you I was going to be handling your appeal. I told you that I wasn't going to do anything unless I heard further from you. And the client was there with his mother. She said, no, that's not what happened. He didn't know it, but this poor client had a mother with an education, bachelor's degree from Mary Walton College. But anyway, the lawyer went in and out of the office, and he produced a letter. He said, here's a letter that I gave you a year ago. It said, I'm not going to, this will confirm our discussion of your appeal, and I'm not going to do anything further with your appeal unless I hear further from you. And the client said, I never got that letter. Well, anyway, the bar investigated the case, went out to visit the lawyer's office, asked for the file, and the original of that letter fell out of the file. The bottom left-hand corner had the secretary's initials. This letter was fraught with typos and wrong sentences, signed by a lawyer. The secretary said, I didn't type that. I wouldn't have typed something like that. When the case went to the disciplinary board, the lawyer tried to explain that my secretary did do this, tried to say she just didn't remember, but the board believed the testimony of the client. They believed that that lawyer phonied up the letter and suspended his license. We offered the lawyer a public reprimand. He turned that down and rolled the dice and lost his license for a few months and never went back to practice law again. But the point is, be honest with your clients. If you didn't get to a case or can't get to a case, let them know. If you're dishonest about it, your disciplinary authorities are not going to like it, and your client's not going to be happy either. Thank you very much for your time, and good luck with your careers.